I'm Lisa Shepard, and I am the Executive Director of the Chief Justice's Commission on Professionalism. The mission of the CJCP is to enhance professionalism among North Carolina lawyers, judges, and law students, a mission which it has been doing since 1998. One of the ways that the CJCP does this is to sponsor this historical video series, which is a collection of video interviews of distinguished lawyers, judges, and professionals from across North Carolina. The CJCP began filming these video interviews in 2000 as a means to preserve the thoughts of these bar leaders on the legal profession and on professionalism issues. All of the videos in this series are available to you on the CJCP website and the CJCP's dedicated YouTube channel. We are so fortunate to have had many distinguished members of the North Carolina Bar over the years, and they have much accumulated wisdom to share with us. It is important to understand that the practice of law is a profession, and doing it well requires not only substantive knowledge that one gains in law school and from studying for the bar exam, but also the value of experience learned from other lawyers. I hope that this video series will give you not only a fresh insight into the person being interviewed, but also some meaningful information about how to be a better lawyer in your own practice. Enjoy, and remember, esse quam videri. Strive to be professional in all that you do, rather than to merely seem so.
Hi, I'm Mel Wright with the North Carolina Chief Justice's Commission on Professionalism. I'm here today to interview Justice Harry C. Martin for the historical video series of the Commission. And we're here in Asheville, North Carolina, and I'm honored today to be sitting with Justice Martin. And Justice Martin, I thank you for agreeing to be here to share a few thoughts with us today.
Well, I'm happy that I'm able to be here, and it's a delight to help and participate in what the Chief Justice and plural Chief Justices are doing in this professionalism project that you have.
Justice Martin, there'll be a number of law students and young lawyers who have the opportunity to see this interview. For those that do not know you, where did you grow up?
Well, I was born and raised in Lenoir in Caldwell County, and in Blowing Rock, which is in an adjoining county. And I spent my early years down there. I think that I was probably one of the last group of people who had a childhood. I was born in 1920, so you can see that in the days that I was growing up, money was not an easy thing to come by, particularly after the crash in '29. And we had to make up our own games and passage of time. And there was a lot of children playing together with each other, mostly out of doors, some indoors. And I was also very fortunate to be there in the town of Lenoir and in the Lenoir schools for the principal reason that Captain James Christian Harper was from a wealthy family in Caldwell County, and he left the banking business, which he was very successful in, and became a teacher of music and band music. He formed a high school band, and I was fortunate enough, along with at least 3 of my brothers and sisters, to have the privilege of learning music and learning how to play a musical instrument. My instrument was the baritone horn and the trombone, which are very similar in being able to, if you can play one, you can play the other, at least to some extent. Captain Harper helped so many people, young children, to have a method in which they could further their education after high school. And that was by music. For instance, myself, I had financial assistance from University of North Carolina because I was able to play in the university band. And without that, without having that background of music and the money that I made off of it in the classical sense and also as a jazz musician, where we would be paid for playing for dances and things. Without that, I might not have ever gone to college.
But you did go to college.
But I did go to college.
And you went to UNC in Chapel Hill.
I did. And an interesting little story about that, I was accepted to Davidson College as well as university, also for musical reasons. And I was hitchhiking to where I was going. I wasn't sure which school I was going to till I got to Statesville. And then there wasn't no interstate in those days. And in Statesville, the roads forked, and you took one road south down to Mooresville and on into Davidson, or you took the highway east on into Winston-Salem, Greensboro, Chapel Hill. As I was walking across the square to look at the signposts, a car pulled up full of young fellas about my age, and the window rolled down, and it says, "Are you going to Chapel Hill?" I said, "Yes." I made the decision right there that I was going to Chapel Hill, not going to go to David. I got in a car with him and went to Chapel Hill, and went to see Dr. Slocum, who was the head of the UNC band. And I went in there and I said, "Dr. Slocum," I said, "I don't have any place to sleep tonight." And I left coming to Chapel Hill. I had all the money that I had was $48, had in my pocket. And so he got on the telephone and got me a place to stay. And later on he got me a room in the third floor attic room up there in one of the boarding houses. And by having that background in music, it opened the doors to me, not only to get into the university, but also to become a part of a jazz band, make a little money there. He got me all sorts of jobs. And when I graduated in 1942, June, I was making a lot more money than I made a week later when I was inducted in the United States Army.
What year did you go in the Army? 42?
1942 in June. And I never, from that day on, I never played the musical instruments any longer. I thought about it from time to time, but I never did, although I still enjoy music to a high degree. So there I was in Chapel Hill and going into the service, and I spent 2.5 years overseas in the Pacific in various areas there. I started out in the Solomon Islands, and I ended up in the Guam area there, and came back to the United States in 1945 on a 45-day leave, and I was supposed to go back to Saipan, and while I was at home, they dropped the first atomic bomb, and I went back to Fort Bragg, as I was assigned to do, and I went in and I talked to this officer there. I was an enlisted man, and I told him, I said, my orders say I'm to go back overseas, and I said, this war's going to be over, and you'd be wasting money and time. Send me over there. They turn around, they send me back 6 months later and discharge me. He said, well, your orders say that's where you go, and that's where you go. So I said, all right, sir. And I turned around and started to walk out. And there's this little fellow sitting over there in the typewriter, and he's motioning me. I went over to him, and he said, come back and see me at 2 o'clock. I said, all right. I came back at 2 o'clock, and he had a new set of orders for me signed by some captain, or at least the captain's name was on it, and I took it that he had signed it. And I had another 15 days, and he said, 15 days from now this will all be changed, and you won't have to go back. So I went on back home, Blowing Rock, and came back, and he was right. And I got back and said, no, you're not going to Saipan. You're going to be discharged. So I was discharged in September the 19th, and went to Harvard Law School in October, about a month later. And I had been previously admitted to Yale Law School, but my older brother, who his physical condition wouldn't let him be in the service, he'd gone to law school, and he was up at Harvard. And he kept writing me letters. You don't want to go to Yale. Says Harvard's the place to come to law school. And he kept that up. So finally, I wrote them to Harvard, told them what was going on. And they wrote me back and says, well, we'll take you. So I went to Harvard. And of course, you had the GI Bill of Rights. Paid our tuition, paid the money for books, and paid our dormitory room, and gave us a check every month for the entire time they were in school up there. Almost all of the before my class entered, there were about 30 students in a Harvard Law School, and they admitted 250 every 3.5 months, year round. And so you can see how it grew. Well, I got out of law school, and while I was in law school, I started looking for a job, and I had a cousin. He really was a cousin, but we called him Uncle Julius. His name is Julius Caesar Martin, and he was the first cousin to my grandfather. And he was a lawyer, and he was in the Washington, working for the government in the Justice Department, head of the War Claims Division. And I went down there to ask him to if he could help me get a job. And he said, yes, I can help you get a job. I can put you to work right here. But he said, you don't want to do that. And I said, I don't? He said, no, you don't want to do that. He says, you ought to go to Asheville, North Carolina. He had practiced law in Asheville for 20 years before he came to Washington. He says, I've got a room full of law books down there and law furniture for your law office. He said, I'll give it all to you. He had a son that had practiced law, but his son was deceased. He died at an early age. He said, so I said, well, I appreciate that very, very much. I said, can I let you know about that? And he said, yes. Well, I got to thinking about it, and I wrote him a letter and says, I would like to go to Asheville. And so he transferred all that material to me, and that's how I ended up in Asheville.
Well, now, when you came to Asheville, as I understand it, you started your own practice. You were right out of law school.
Right.
Had not practiced for a while and had no experience. Tell us what it was like to start out on your own, in your own law office, because I think we're going to have a lot of young folks now coming out with the economy as it is today that maybe start their own firms or not going into practices. And did you have a mentor, and how did you make it on your own?
Well, I really didn't have a mentor, as you think of it. But I made up my mind, and as I reflect on it, Uncle Julius may have suggested this to me, and I can't remember for sure. But one of the first things I did was I went to see every lawyer in Asheville. There weren't too many, but I went to see every one of them, introduced myself, said I'm here, I'm practicing law, and this is where my office is, telephone number, and if you have anything that you think I could help you with or do for one of your clients, you just let me know and I'll be right here. Well, it took a little while for that to begin to happen. First month I practiced law, I made $15. My rent was $30. I rented an office from Joe Huff, who's a lawyer there in Asheville, and his wife was his secretary, and she said that she would do my work, which wasn't anything for her to do, but she said she'd do my work without any cost, and that was a footnote to it also, because later on, when I was a Superior Court judge, the state finally found enough money so that the Superior Court judges could have a secretary. And so I got Miss Huff to come and be the secretary for the judges. And she did. And then later on, when I was appointed by Governor Hunt to the Court of Appeals, she came in and told me, says, you can't go unless I go too. And so she went and she stayed with me up until about a year before I had to retire. She left about a year before I did and came back. But coming back to that practice, I would say that one of the most satisfactory things is to open your own office, and it's your own responsibility. Either you do it or you don't do it. And if you work at it and devote your time properly, you'll get business. And very often, in those early days, a lawyer would send somebody to me because he was too busy to attend to it. Well, the next time that guy needed a lawyer, he came to me.
Right.
And it just gradually grew. And also, fortunately, the Roosevelt administration had the foresight to know that a lot of veterans were going to be starting in business, so to speak, and would need help. So there was a program where I got $300 a month from the government for the first 18 months, I believe it was, might have been 16, that I practiced law. It was known as the Veterans Readjustment Allowance, kind of bridging you over from your income as a serviceman to your own income that you're earning yourself. And there were a lot of us out there drawing that $300 a month, which was a great thing. But very soon, there were Lamar Gudger and Bruce Elmore were both struggling along. They had been at the bar about the same, a little bit longer than I had, not much. And so we talked about forming a partnership, and we decided that we would pool our deficits and form a partnership, and we did. And I was in that partnership for 11 years, practicing law there.
Did
So-
you specialize in any one area or
No.
any type of practice?
No, we had a very general practice of law. We represented plaintiffs in cases, automobile cases, all kinds of cases. We represented people, husbands and wives, and marital disputes and so on. And we represented criminal defendants of all kinds. And back in those days, there was no public defender, and the judge would very often look down and would say, "Well, Mr. Martin, will you represent Tom Smith here in this case?" And you would take him and represent him. And when you got through representing him, the judge said, "Thank you so much for helping him," but
right.
you didn't get any pay,
Right.
but you got practice.
Right.
And the next time he got in trouble, he came to see you,
That's right.
and maybe got a little money up to get you going. You did, if you were appointed to represent somebody in a capital case, and I was at least 3 times, the judge could pay you, and the state would pay up to $250 for representing somebody in a capital crime. Today, that's all changed.
Well, after working for a while in that firm, was the next step for you to go to the bench?
It was, insofar as my career was concerned. I did take another big step after I'd been practicing law for, it was about 7 years. I got married. And that's the longest contract I've ever been in. It's still going on. And then in 1960, Terry Sanford ran for governor, and we were, as the other side called it, we were Sanfordites. And back in those days, the Republican Party had very little clout. Most of the battle was between the, I'll say, liberal, I won't, no, without any bad feeling of liberalism, the liberal crowd and the old-timer crowd. We call them the mossbacks. The mossbacks were the old-timers, and the new crowd were the mossbacks called us liberals. So Terry got elected, and at the same time he got elected, John Kennedy was elected same year, 1960. So everything was pretty much going our way. The young lawyers who had almost all of the seats in the legislature up here were young guys. We went down there, and Terry, I'd known Terry when I was an undergraduate at Carolina. He was in law school. His girlfriend, whom he subsequently married, was in my class, and I knew her very well, and I met Terry through her, and we became friends. Although during the war and the law school period, I had very little connection with Terry. But once I started practicing law, I got into the Young Democrats crowd, and Terry was Terry ran to be president of it, and we took a busload. We took a busload of Young Democrats from Asheville all the way to Wilmington. Now, Wilmington, the people down there did not know we were coming, and they had thought they had enough votes down there for George Fountain, who later on was a Superior Court judge, and a very fine Superior Court judge at that. But they had thought they had it locked up. And here we came. We had about 19 votes coming in there Saturday morning, right before the election. And we carried it. And it was too late for them to scout around and get enough people to overcome it. And Terry got to be the president of the statewide. And he managed Carr Scott's campaign when Carr Scott ran for governor, and he was elected. And Terry, let's see, I think there were 4 ran for governor, and 2 left, Terry and the runner-up, and Terry won in the second go-around. And he knew I wanted to be a judge, and I really didn't think much about being a judge until I started practicing law. And I sort of got the idea that's what I'd like to do. And
What did you learn as a Superior Court judge that you could share with us?
well, a Superior Court judge, the most dangerous part is talking too much. Superior Court judge has to quickly learn not to say much, because you really don't need to. Somebody says objection, overruled. You don't have to say overruled, blah 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 blah. Tell why you're overruled. Don't have to say that. you tell why you're overruling. Some appellate court may say, no, that's the wrong reason. He didn't overrule it for the right reason. So judges, Superior Court judge especially, has got to learn to say little and to listen a lot. And I think the Superior Court judge, people have asked me, I sat on all three courts, as to which one I thought was the most important. And I told him I thought the Superior Court judge was the most important because he's all by himself. There might be another Superior Court judge in the courthouse that he could talk to, but that's be the only guy he could talk to about a problem he might have. Whereas Court of Appeals, you got a panel of three, you got two other guys to help you. Supreme Court, you got 6 other people to either help you or confuse you.
Well, now, after the Superior Court judgeship, did you go to the Court of Appeals?
I did go to the Court of Appeals.
What year would that have been?
78.
Okay.
Yeah, 1978. I was appointed to judicial office by 3 different governors, Governor Sanford, Governor Moore, and Governor Hunt. And Governor Hunt made the same mistake twice. He appointed me twice to the court, to the Court of Appeals, and then to the Supreme Court. I enjoyed the Court of Appeals work, but I think I served just about the limit of what a fellow ought to have to do. I remember the last year I was on that court, I wrote 105 opinions.
For the Court of Appeals in 1 year?
In 1 year on the Court of Appeals. That's one about every 3 days, roughly. And when you throw in Saturdays and Sundays, that's a lot of work you're doing. Supreme Court, you might write 25 opinions in a year's time, something like that, maybe.
How long were you on the Court of Appeals?
4 years.
And how long were you on the Supreme Court?
10.
10 years.
Yeah.
Okay. All right.
And I mentioned to you earlier that I did not like the mandatory retirement which the legislature had passed, saying if you got to be 72 years old, you were too old to be a judge. And you look at the Supreme Court of the United States, you got one justice up there now. He's the same age I am. I believe he's 89. And he's still serving on the U.S. Supreme Court. And there have been lots and lots of justices, and lots of them on the court here in Raleigh that are over 72 years of age. But the legislature, in their wisdom, decided that after you reach a certain age, you couldn't no longer be a judge. And I think a trial judge, he can't be a judge after he's 70, I believe it is. And what the difference is, I'm not sure, is they give these guys in Raleigh that they can stay for 2 more years, and the guy up here on the Superior Court can't do that. But they really don't have to explain what they do. The legislature just does it. And trial judge doesn't have to explain what he does, but once you get on an appellate court, you got to have some explanation about things to put in writing.
Well, what year was it when you stepped down from the Supreme Court, approximately?
It's 1992.
And what did you do after that? Did you just retire?
I retired for a short time. My son was practicing law in Hillsborough, and he asked me, he says, while you're thinking about, at that time, we were living in Chapel Hill. We had moved to Raleigh, and then we moved from Raleigh to Chapel Hill. Had been in Chapel Hill about, I guess 8 years by the time I retired. So I went up there to Hillsborough on Monday morning, and my son Matthew was there practicing law, and he said, we got to go in here. We got a driving under the influence case to try. So we went down there and tried that, and we lost it. And we tried the next 15 driving under the influence cases that we tried. We got verdicts of not guilty, and that's in the district court without a jury. That's almost a miracle.
Yes, it is.
to do that. But I practiced a little law, and my friend Judge Sam Ervin, Senator Sam's son, was head of the Fourth Circuit Court of Appeals at that time, and he called me, and he knew I had retired, and said that he wanted me to join the Fourth Circuit as the Chief Circuit Mediator and establish a mediation program. And I told Sam, I says, how are you going to settle cases when one side is won and the other side's lost? He said, well, we don't know, but we're going to find out.
Well, and the thing that I've thought about is that in 1994, when you started that as Chief Circuit Court Mediator, we didn't have mediation to the extent that we do today.
That's true.
And tell us what you think about the mediation process and what difference it's made.
Well, the mediation is a good thing for lots of cases. Not every case, but cases where there's not too much personality in the case, or if it's just dollars, those kind of cases can be mediated pretty well. When we started the Fourth Circuit, I thought that the holdout would be the guy who won in the trial court, and that he would not want to give up what he had. But it turned out to be just the opposite. The guy who lost in the trial court was carrying on his shoulder, not only did he lose monetarily, but the judge didn't go along with his idea of the law. And this fella, the loser, he wants to change the law in addition to settling his case. But he has that thing in the back of his mind about the law. So when they come up to mediation, the guy who won the case, he can be gracious, and he can say, well, we'll be happy to reduce our claim by 5% if he'll pay in cash, and we'll get this case behind us. And when the guy starts out with that, well, you end up maybe settling that case for 6-7%. And I was amazed at the number of cases that we were able to settle. And there was another thing that was influential in that. There were a couple of things. Is the Fourth Circuit was, and perhaps still is, to maybe not as great an extent, but it was a very conservative court, and there was not much overruling the trial court. And I would explain that. I would have these charts made up of 100 cases in the last period of time have gone to the Fourth Circuit. 87 have been affirmed. Now you take your chances. You got about a 13% chance in there. So it was very successful. When I left, I stayed with them for about 6.5 years or 7 years. But when I retired from that, I think we had 3 other mediators. We did, and myself and 3 others. We had 4 of us working as mediators, and I remember the Fourth Circuit would file a paper at the end of every year showing how many cases been settled in mediation and showing the number of cases that any one judge on the Fourth Circuit delivers, and it so showed that we were doing the work of about 3 additional Fourth Circuit judges being on that court, getting rid of that many cases. So it saved the country a lot of money, in addition to terminating cases on good terms.
Well, and I agree. It's a terrific program, and it has done a lot for backlog of cases, if you will, to reduce that.
Yeah.
And after that, did you retire? Did you go home and stop any form of the practice of law?
Well, I never did completely stop practicing law. Every year I filed with the State Bar in Raleigh and got a license back and so on. But I was pretty much retired for about 6 months when I got a phone call from Principal Chief Jones at the Eastern Band of Cherokee Indians, telling me about the Cherokees closing out what they call the CFR court, a court under the Code of Federal Regulations, which is actually a court run by the Bureau of Indian Affairs, and everybody who worked in the court system was a federal employee. They were not employees of the tribe. It was a federal court, not a tribal court. They wanted to terminate that. Congress had passed a statute which said if a tribe wants to take on an event, a program which the federal government is presently funding, that if the tribe takes it on, the federal government will continue to fund it at the same level that it has been. And that includes things like hospital, which the Cherokees have taken over the hospital, and the school system, and the court system, and there may be some others, I don't know. So we had a background of so much money. I've forgotten how much it was, that the feds would pay, and then the tribe was just beginning to get money from the casino at that time. And so I talked with Chief Jones, and he convinced me to take that job, and I did. And I told him that I couldn't move to Cherokee. He said, that's all right. And so I drove back and forth. It's 50 miles each way. It's 38 miles to the Indian reservation. The last 12 miles, you're driving on the reservation property.
And that's 38 and 50 miles from Asheville.
No, it's 38 and 12.
38 and 12. But
Yeah.
I mean, the
It's
point
50
starting
over, 50 back.
from Asheville.
Yeah, from Asheville.
Right.
100 miles a day
Right.
back and forth, which is not too bad. It takes about an hour and 20 minutes every each way.
And what type of cases did you hear in that capacity with the,
Well, I was on the Supreme Court, and I only heard, there were three of us on the Supreme Court, myself and a Cherokee Indian who lived in Washington, D.C. She was a graduate of Duke University and Columbia Law School, very bright young woman. And the third judge at that time, he was from Macon County. I can't think of his name, but he was a white man, not a Indian. And we hired him. The court hired him to participate on the cases. So we only had one Indian judge, and myself and this other guy. The trial division had three Indian judges. One of them is still there. The other two left. None of them were members of the bar. Two of them had been to law school, but had never passed the bar exam. The third one, Kirk Sonuk, had never been to law school. He had an undergraduate degree. I told him he had to go to law school. He said, "Oh no, I can't do that." Yes, you can. So it took me about 2 years, but I finally got him into Chapel Hill Law School, and he graduated down there, and he passed the bar. And now he's back still working as a trial judge. They try all kinds of cases. Unfortunately, in the view of the Cherokees, Congress has passed a statute and says that for any criminal offense on tried by a tribal court, you cannot sentence him more than 1 year in prison or a certain fine. I forget how much the fine is and the cost. So in practical way, somebody charged with a big drug felony, justice could not be served if he's convicted by punishing him under that law. So those cases, including murder cases, rapes, burglaries, all the heavy crimes, they go to the United States federal court sitting in Bryson City. They have a courthouse in Bryson City. And those cases are tried down there, or they're tried in Asheville, one of the two, by the federal court. And although they could be tried in the tribal court, but as a practical matter, most of them are not. And the principal criminal jurisdiction of the Cherokee Tribal Court is about the same as a district court judge in the state system. Now, on the civil side, they have unlimited jurisdiction. They can try any kind of civil case at all. And they just finished trying one over there that lasted for 3 weeks. And the jury, on the last day, one of the jurors' father died unexpectedly. And so they had to withdraw a juror and declare a mistrial in that case. It involved Harrah's. There's a lot of litigation out of Harrah's Casino. Everybody who goes over there knows that there's plenty of money at the casino.
Right.
So if anything happens, a lawsuit comes along after it.
Let me ask you this question, Justice Martin. You have had a wide range of experience with the practice of law and sole practice and a partnership and on all levels of the trial bench. What important aspect of professionalism do you think young lawyers need to be aware of as they start out practicing law?
Well, I think the important thing for a young lawyer is to remember, and I'm not denigrating other occupations, but to remember that you are a professional, and there's a lot of difference. You are not in a business to make a certain amount of profit. You do not have other people's money invested in your business, and you do not have other people pressuring you. You've got to make more money. The practice of law is a true profession, and the principal objective of the practice of law is to help people, not necessarily help businesses. You can help businesses, corporations, and the like, and there's nothing wrong with that. But the basic bedrock is your job is to make life better for the people who look to you to help them achieve that. And I think that if you remember, if a young lawyer remembers that, well, that's what he needs to do. I remember an older lawyer telling me years ago, says, if you do this, if you mind your office, and if you do your work, you don't have to worry about making money. The money will come to you. You don't have to. That is not your goal. Your goal is to help the person, or more than one. And sometimes it's a very difficult thing, especially if you have 2 people or 3 people or more people with different ideas, and they're all come to you and want you to resolve it all. It's sometimes a very difficult thing to do. But if you keep in mind, if the young lawyer keeps in mind, is there anybody, it's 5 o'clock, I'm getting ready to go home, is there anybody here in Buncombe County better off today than he was yesterday, because what have I done to help him? I think that those are if you do that, you need to worry about the money part. It's going to be there. I think that the young lawyer has got to preserve also in doing his job. I guess there are lots and lots of lawyers that couldn't find the courthouse if you'd ask them where it is. And lots of them, if they know where it is, never go there to try a lawsuit. But those who do, those who go into that courtroom, should remember that there's a difference between a lawyer and a judge. And we must continue, although you may not have good feelings and a good personal respect for a certain person who happens to be a judge, the fact that he is a judge entitles him to you be courteous and treat him as if he were, in your mind, a good judge. And that will help him as well as help you. And you do it by the simple little things, remembering the rules. If you want to say something to the court, you stand up and you say, "May it please the court." And you don't say, "Well, hey, Judge, what about so-and-so?" You know, you address the court as either "May it please the court" or "Your Honor." That's the 2 ways. Don't call him Judge while he's up on the bench. If you meet him in the hallway, "Good morning, Judge, how are you?" That's fine, but not when he's on the bench. And you mustn't remember that you have to get permission to approach a witness, to approach the bench, to approach a juror, to hand the jury a paper. You just can't get up there and go walking over to the jury. You got to bear in mind how things are supposed to be done and do it in that fashion.
Justice Martin, we've just got a couple of minutes left, and before we finish, I just want to thank you on behalf of the lawyers of North Carolina and the citizens of North Carolina for the wonderful career you've had of public service, of respect for people of North Carolina and the lawyers, and for doing such a wonderful job, and for continuing to do such a wonderful job, and for taking a little time today to be with us so you could share your career with us. I thank you very much.
Well, I appreciate that very much. I feel that the public has helped me rather than me helping them. I mean, after all, I've had 3 different governors appoint me to office. I've ran statewide in elections 5 times, won every time. So the folks out there have given me the opportunity to do what a little bit I could do.
Thank you very much for that.
Yes, sir.